Uh, Hello everyone. Can you people hear me and see me? Please write in the chat box if you can hear me and see me. Hello. Okay. I think people can hear me and see me. So a warm good afternoon to everyone. So as you know that we'll be discussing today's session regarding IP and fintech. So just to start with, Uh, the session would be broadly, discussed around these pointers, which will be like basic information around fintech, why to protect IP in fintech, what IP to protect in fintech, and how to protect IP in fintech. So the way the session would go, like the major portion would be like a monologue where I'll be presenting and discussing about these aspects. And towards the end, possibly if there are some questions I need to take, I will be taking them, and we can have some dialogues. Okay. So right now we'll start with the presentation, and so so to start with, the basic information around fintech is like I have included three things. It's like the definition part, the origin of the term, and the current financial position. So as you know that the term fintech is a is an amalgamation of two word financial technology. So it's pretty much very simple to understand that that anything, any technology that works towards enhancing, automating, and delivering the use of financial services is something related to fintech. So some examples are like related to mobile payment, fund transfer, online banking, virtual currencies, on-demand retail payments, so on and so forth. So it will not be wrong to say that as soon as the barter system ended, the financial technology came into being, and we have witnessed so many changes in the financial technology that uh, uh, sorry, just pardon me. I just wanted to know like whether I am still live or not. So in case I am, I'll connect again. Let me check with my support system, and I'll get back to this. Yeah, just excuse me. Sorry. Okay, I have a confirmation that the session is live right now. So coming back to the definition point, like we know that anything Fintech deals with anything which automates the delivery and use of the financial services, and the examples are like mobile payment and all those kind of things. Okay, so the term fintech was coined back in 1980 by Peter Knight, the editor of business newsletter in Sunday Times, but it was not very well known till the time 2007 and 8 recession come. So at the time when market crashed, so the uh, angel investor or venture capitalists, they started investing a lot on fintech and primarily on startups and tech companies. So then this word started getting regularly used in the in the market, fintech. Then from the current financial position point of view, the fintech market is right now valued for the 2022 in of around 310 billion. And from Indian perspective, the fintech market has attained unprecedented growth and ranked third largest globally, which is nearly 31 billion. So having said that, it's the 10% of the entire worldwide valuation can be associated with India. So you can say that there is a lot of thing going in India in terms of fintech advancement. So now we'll talk about the why we should protect IP in fintech. So we know that like any other technology domain, IP helps in securing the monopoly over inventive product features and exploit them commercially. So the fundamental reason why we should protect IP in fintech is definitely to have monopoly over your inventions and exploit them commercially. But in addition to that, there are other aspects also for which you should protect IP. And the first and foremost thing is you should protect IP because to protect investment in the proprietary technology. You know that whenever we are building something, definitely a lot of R&D things goes into it. People invest a lot of money, time, energy. So in a way, if you are doing something, so IP should be in place in order to protect that investment. Second thing, it should be like securing investment and increasing bargain power. This is more associated with startup. Like if you want to raise some fund and you need to have a bargaining power, if there is protected IP, granted patents, or not granted, at least applied patents, copyright, trademarks, and such kind of stuff, it provides you an edge or helps you in giving a bargaining power. Then the third point is like collaboration and licensing. When it comes to bigger organization, you can collaborate with them or you can license that technology to them, and it very much applies for the bigger organization as well. And then the point that I'm trying to mention is like if you protect fintech in IP in fintech, then you can cover a fair portion of competitive technology space. You know that every day this uh, every day is the technology is changing, right? So uh, so like the way I have said, if you see the technology evolvement in fintech, initially as soon as the barter ended, we used to exchange coin, then the paper currency came into picture, then plastic currency came into picture, and then finally now we are dealing with virtual currencies. So definitely having said that, uh, you can understand there is a good amount of shift in the technology space, and every day it is changing. So filing IP in such areas will definitely give you an fair portion covered under you. So you should go for filing IP in fintech. Then uh, then if you talk about like what IP should be protected in fintech, uh, the way we can think of is like by filing utility patents, design patents, trademark, copyright, trade secret. So this will be very much known to the people who are in IP domain, that why we file patent. Patents are definitely, for protecting any idea which is novel and non-obvious. Patent has functionality which is different, or which makes it different from the rest of the IP, like design, patent, trademark, and copyright. So So you can file utility patent to protect any idea which relates to any product, process, machine, device in the field of fintech. Yeah, under design patent, you can protect appearance, that is look and feel of physical items such as electronic car, transaction devices. And apart from that, you can also, file design patents around GUI for any softwares that you have made, which gives you an edge in terms of, your competitors. Then trademarks covers mark, logos, icons typically used for the branding of the business. Then copyright similarly protects program code, visual interface features, audio, video guides, application programming interface, and so forth. This last part, which is trade secret, that is a little bit interesting. For trade secret, you don't have to essentially file any application with any government organization or PTO. It is just by the virtue of it's just there. The right is with you. It's just that you have to take adequate, measure in terms of keeping that thing confidential, so that people do not, get to know what exactly how the trade secret works. So trade secret, one aspect is that like a patent and every other IP has a time associated with it, but trade secret it can be used as long as you want to use, provided you are keeping it confidential. So that is something which could be kept in mind. But the one catch with trade secret is that if somebody reverse engineers and comes up with the same thing, then you won't be able to stop them. So idea is just you can keep it confidential so that nobody can use. But if somebody cracks it, then you cannot stop that person from using. Now, from the patenting perspective, the major patent filers are USA, China, South Korea, and Japan. And so to say, the traditional financial institution like banks and all, like Visa, MasterCard, Bank of America, the major patent, filers. Apart from that, there are tech companies also. Facebook, Apple, Google are also one of the major players in fintech technology in terms of filing patents. Interestingly, IBM owns the maximum number of patents in the fintech technology, which is around 5 times more than the fintech, patents compared to banks and payment companies. So when I know that IBM not as such, they are the front runner in terms of filing patent in fintech. They do a lot of filing in other domains also in terms of software, hardware. So they are the leading firms when it comes to filing the number of patent. So is to say that they are front runner in fintech also. So now we'll go to the most important part of this presentation is like how to protect IP in fintech. This is the most important part where we will be focusing on the possible challenges while protecting IP in fintech. Then we will analyze few granted patent so that we can overcome some possible challenges. Then we'll see some key technologies and read about some notable patents. And finally, we will discuss about the basic, approach or strategy one should have while patenting in fintech. So to start with, the possible challenges while protecting, IP in fintech is majorly associated with patents. With, if I say patents like IP, like design patent, trademarks, copyright, they are pretty much straightforward in terms of getting protection over. So you can file them and get protection over that, unless they genuinely lack originality. So what I meant by that, if it's not infringing upon somebody else's design, trademark, copyright, you will definitely get protection over that. And with the trade secret, that there is no requirement as such you need to file any application. So you are just required to keep them confidential. So that's it from the trade secret perspective. But as I said, the major challenges lies with the patent, because they are generally considered as patent ineligible subject matter or non-patentable subject matter because of the reason they are either considered as business method patents or software per se. So I will talk about the various jurisdiction perspective. If I talk about US, under 35 USC 101, software applications are considered as an abstract idea. Under Article 52 of European Patent Convention, doing business and programs for computer are not be regarded as invention. And under 3K of Indian Patent Act, mathematical method, business method, computer program per se, or algorithms are considered as not patentable subject matter. So we know that these laws are there in place in order to, challenge most of the patent work in fintech, because of the reason they are primarily either thought as like they are leading to business method, or they are software per se. So these are the things why patenting or getting grant in, patent in software, fintech technology, it's very difficult. And there is a special mention I want to make to Alice Corp versus CLS Bank. We know that this is a landmark case in 2014 where Supreme Court of United States clearly mentioned few guidelines as to what is patentable in the name of software. I will just give you a little bit of brief around Alice Corp versus CLS Bank. Basically, Alice had a few patents in their name, which were dealing in terms of, uh, scheme to protect against settlement risks. So basically, they were like, if there is a risk of settlement is there, so there will not be a transaction happening. So these kind of patents they had in their name. So for example, if there are two parties which needs to engage in any any business activity. So, and for that, both the parties need to have adequate bank balance in their respective banks or with their institutions. So, in order to check that, the Alice had those patents in place, which used to use a third-party software to make sure whether both the parties have adequate balance in their bank in order to make those transactions happen or not. And if the software or the patents or the other they will check whether there is a sufficient balance is there, and once that is there, then they will make the transaction go forward. So this was what Alice had in patent, and similarly CLS Bank also had businesses or services in the same technology. So what they did, like they when Alice sued CLS Bank put in a counter suit and tried to invalidate the patent, and eventually it got invalidated. Very interestingly, there was a bench of 10 judges, and 5 of them were in favor and 5 were against. So, but the former judgments were against Alice. So I think they went ahead with giving against Alice Corporation. So what fundamentally Alice case lied down is like, if there is any known method, that will be considered as abstract idea, in the sense, if there is any known method which is being used by people earlier, and now with the help of computer we have made it a process which should be done with the help of a software. So these kind of things will not fall in the category of uh, patent eligible matter, or you will say they will be abstract ideas. So if I associate Alice versus and fintech, then there is a very interesting thing that has happened in recent past. Is like, there was a patent which was owned by Western Express bank share. This one, the US patent, which was relating to a method for transferring fund through a bank card. So what they did, so they sued Green Dot Corporation, and then Green Dot Corporation bought a counter suit, and in the counter suit, the patent 932 got invalidated. So to say, that already there are laws like 101, 35 USC, Article 52 from EP perspective, and Article Section 3K from Indian perspective, which can make things difficult when it comes to patenting in fintech technology. On top of it, the landmark judgments like in related to Alice Corp versus CLS Bank can also cause a lot of problem because in general what has been the observation now is like these uh, you know this case is acting as a deterrent, and people are not filing infringement suit against other parties. So because it might be a possibility that they file infringement suit and then later on, based on the counter suit, they get their patent get invalidated. So this is how the current scenario is positioned in terms of patenting in fintech technology. Now we will discuss few granted patents, and we'll try to analyze, even though there are challenges in terms of getting grant in terms of patent related to fintech technology, but there are possible ways which way you can amend your application, or you can prosecute during the course or period, and you get a grant over your idea, or you can say patent. So this patent is related to code-based or token-based transfer using ATM, automated trailer machine. The applicant is IBM, filed in 2018 and granted in 2021. So the invention was very simple. The idea is to simply send cash from one person to another person who is using the ATM, and that another person did not have to have any bank account or any mobile app or something, like any bank account or something. You can just simply pull out money from an ATM with the help of the sender. So the claim, the way it was constructed during the first filing, it reads like receiving by a first computing device a request from a first user, then generating a code corresponding to the request, wherein the code corresponding to the request is usable by a second user at a second computing device that is configured to fulfill the request in response to receiving the code from the second user. And the second computing device is an automated trailer machine. So the idea is very simple. If I need a money, there would be some sort of communication. That is, the code will be communicated to me. I will use that code in a particular ATM, and I will pull out the cash. So there is no need of having any bank account or card or something like that in order to pull out cash from ATM. So this is the claim which was finally got clearance or got grant. This claim, the granted application has this claim 1. So you can see there is a sufficient amount of text which has been added in terms of putting more clarity or making it narrow, and then to overcome any obviousness or novelty issues. In this bit in particular, there was no novelty issue. Just there was a rejection of obviousness under Article 303, which I am not considering for this discussion. Reason being that I would consider that a patent in any technology, or per se in fintech also, would overcome the novelty and obviousness rejection based on mostly on the merit of the case, but because you can objectively deal with them. But the subjectivity of these patent generalize whether it is falling under patent eligible matter or not. So to say whether they are patentable ideas or not. So I will be talking mostly from the USC 101 and 101 perspective, where it and lists down 4 major categories under which the subject matter is considered as patent eligible, and they get grant over that. So you can see the claim that is being this is the claim which was finally presented to examiner after the non-final rejection, and there was a call between the attorney and the examiner, and there is a and finally the patent got granted after their hearing, or you can say. So so if you look at this claim right now, you can see that the underlying portions are system limitations like computing device, ATM machines. So what examiner did when it raised the rejection under 101, they said like these limitations without the bolder limitation above cover the performance of the limitation as certain method of organizing human activity under this broadest reasonable interpretation. So if I, in the broadest possible interpretation, the examiner felt that this is a human activity, so it's an abstract idea, uh, so it will not be falling under the category of patent eligible subject matter. So they straight away said like we will not give grant over this. So and further it said that these finally they said that yeah, another point that they mention is like these limitations cover performance of limitation as a fundamental economic practice, such as mitigating transaction risk. So what examiners observed is like the way the claim is being constructed, it just talks about mitigating a transaction risk. So again, that is something which does not make it fall into a patent eligible subject matter. So these are the major rejections under 101 for which this patent was not granted, or rather it was argued. So later on what applicant did is like applicant produced the applicant argued that the claim are not directed towards the fundamental economic principle or practice, for at least the reason they are not directed toward hedging insurance and mitigating risk. Although the mitigation risk is there, that they will later on clear that. The examiner does not assert that the claim are directed to hedging or insurance. Rather, what the invention talks about is like aspect like includes talks about the method and system for sending money to a recipient without requiring the recipient to have or use the bank account or digital wallet. So you can see the underlying portion was the part which which was in contrary to the fact that this is not a human activity. It's like rather there's a transaction of money is happening, and that too also without the use or having any card or account or something like that. So the applicant further says like that claimed invention simplifies person to person cash payment using an ATM and is not directed toward mitigating risk. So clearly you can see that this is not about mitigating risk. It's just about exchanging money with the help of ATM or maybe with the help of a mobile phone. So that is how the invention was constructed, and the applicant argued that this is not directed toward any abstract idea because it has a practical implementation. Then further there was a part which talks about generating by the computing a code corresponding to the request and a hash version of the code. So there the security part also been taken care of, where the applicant submitted that hash version of a code is a function that requires specialized code generation module and therefore implemented with a particular machine. So the way it is being run, it is not something normal computer where the code is being generated. There has a specific end to it or a function to it. After the code being generated, the code is used for pulling out money, and for this reason the applicant argued that this is not falling in the category of abstract idea. So then finally the applicant said that the ATM is not a generic computer, something like which does some generic function. ATM has a specific function of uh, disposing cash or money. So they had in the application they wrote very elaborately about the ATM machine. So they argued the fact that that but like this under PEG, this ATM is a particular machine, it's not a generic machine, and decide that because it does not even it's not only first of all it is not directed towards just mitigating risk, and then the ATM machines are not something which is very generic in nature. So these are the two major arguments that the applicant put forward in terms to argue that this application is falling under the patent eligible category. And after the discussion with examiner and attorney, this matter got cleared, and this patent got granted. So now, with the analysis of this patent, we can see that there is a good amount of change that was made in the claim in terms of how it was initially filed and at the time of grant. So content was borrowed from the specification and put into the claim in order to make it more clear or narrow, maybe to overcome obviousness, because there were some prior art which were cited as 103 objection for the obviousness aspect, but our applicant argued very well in terms of overcome that. And then the later part, that what was done here is like the applicant really argued very well. So these are the two things which has been done with respect to this particular patent application. So having said that, we can see that if the application is written well and prosecuted well, then definitely you can get patent in fintech. So now, similarly, on the same lines, I will talk about the second case, which is a granted Indian patent. This is a fairly simple invention, and very interestingly, it was filed like in the year of 21 and got granted in 22. Very quick grant. So we know that Indian jurisdiction as such is not very easy with software patent, and I can assure you, if you file any patent related to fintech, you are definitely going to get a 3K reduction. So that this patent was related to making payment without using card in a case where you are using a POS or a point of sale machine. Like in a nutshell, if you go to any shop like Walmart or say Big Bazaar, and you buy stuff from there, and you eventually realize that you don't have card to make payment, so there is no worry. You can simply use the point of sale machine, the card reader, or the machine that is used for swiping the card, and you can make the payment using that machine only. So the patent talks about, like, very simply, like entering by a point of sale module a mobile number of the user and amount to be paid by the user. Then routing by the POS provider the connection request to a service provider module payment, and then finally triggering by the service provider module a payment request to a payment engine. And upon validation of the payment request, the payment is being received through the machine at the point of sale. So what was done here is like this application presented couple of scenarios, like how the payment can be made. It was like if it is using a UPI, so you can just the request is initiated by the pre-registered VPN, and the user accepts the same through the PSP app. So you can just click on the UPI request and the payment can be made, like on your mobile phone. And similarly, if there is a validation method like using PIN, so you can enter the PIN of the card possibly, and then you can get the payment made. So then there is OTP. If there is an OTP received at the customer's mobile, so he can enter that OTP in the POS and you can make the payment. And finally, there was a PIN on USD, like it's a GSM code related thing. So there you can make the payment. So using OTP, PIN, and by clicking any UPI interface and all those things, you can certainly make the payment. So here the idea was to simply make payment without using the card, like debit card or any credit card. So as we can very well anticipate, the Indian Patent Office cited the 3K rejection in this patent regarding this patent. So what they did is like they mainly raised the 3K objection and they also had some inventive issue related, like there were some parrots which were considered and made like this is very obvious in light of those parrots. So I'm not going to talk about that. But what they did in they said like the claims were non-patentable under the clause K of the section 3. They said like uh, within the scope of the meaning of the program per se or algorithm, section 3K of the Patent Act, as such, this is not allowable. So they said that the claims which relates to a method for a user to make payment, without using card, falls under the purview of program per se or algorithm under section 3K. So they are not patentable. So what applicant did is like, very interestingly, this was initially filed and the patent got granted in the same state. Like there was no change or there was no addition or deletion was made in this claim. Simply the claim which was presented during the first filing, the scope remained the same during the grant. So this is the only the first file and the granted claim. So what basically, so now we can say that there was no any substitution of text in the claim. It's rather the ability of the applicants to argue with the examiner and making them feel that, okay, this is not falling under 3K. So this is what being done. So applicant made a reference to CRI, Computer Related Invention Guidelines, which was given in 2017. It clearly states that establishing patentability, the focus should be on the underlying substance of the invention and not on the particular form in which it is claimed. So what was important is to judge the substance of the claim, taking the whole of the claim together, and also the assertion or the has to be made like whether this patent has some practical application or not. So after that, the applicant further argued, citing the case of Ericsson versus Lava, where it was held that the invention which results in technical advancement and have practical implementation or physical representation are patentable. So further, the applicant again cited the Ericsson versus Intex, where it was held that computer that are achieve a technical effect, whether by means of hardware or software, cannot be regarded as a computer program per se or algorithm. Applicant also referred to Trade Allen versus Union of India case, in which the emphasis was made on the technical effect part. So along with this, applicant further argued that it has solved certain well-established problem of carrying of card, or like if there is some chip problem associated with the card, or somebody forcefully takes away the card and pulls out money from the ATM. So the scenario possibly where there is a lack of ATM card, or there is no ATM card. So that was argued that this is a well-established problem, and for that there is a practical implementation of the invention. Then from the technical effect point of view, they said like that where the payment can be made on the POS machine terminal emitting the card present scenario, that is like transaction without card. So that was which was argued as technical effect. And finally, they again went back on and referring refer to CRI guideline, where they mention about business method. This is not belonging to the business method category, because they say that business method involves whole gamut of activity in the commercial and industrial expertise relating to transaction of goods and services. However, the claimed invention is not claiming any method for doing business. Rather, claimed invention is directed towards providing a platform where the payment can be made on POS without card. So this is not a way of doing business. Rather, it's just an exchange of money, which is happening at the point of sale, and that too also without card. So I precisely just took into account two patent application only. The one is this Indian patent application and the US application that formally we discussed. So based on the discussion so far, one can easily understand that the two aspects in terms of patenting in fintech is very important. One is how you are writing the patent application. It is to be well drafted so that during the prosecution stage, it is, the person who is prosecuting gets a good support from the written text in order to argue with the examiner. And the second thing is like the person himself who is arguing has to be well aware of the fact that what the guidelines are, what the law says. And so these two things, if are in place, so the possibility of getting grant in a regarding patent in fintech is very high. So with this note, I would now just shift to what are the key technology that is likely to drive the fintech technology in the next decade or in the near future. There is a very beautiful article from McKinsey which says about these 7 technologies possibly could be the market leader in terms of fintech. So far, one must have understand when we talk about fintech, at the core there is a technology which is coming into play. Like when it about like scanning a QR code and sending money, so the QR code is coming into picture, right? If there is a message, for while putting an OTP for making transactions, so the security aspect comes into picture. So fintech would be always associated with some core technologies, and in the upcoming days, these technologies would be the market leader. What is being projected, or like people are thinking like from the study point of view. And those technologies are artificial intelligence. We know that artificial intelligence is used for identifying some pattern in data and doing the calculations and all those things. Then blockchain, again, secured transaction, cloud computing, IoT, open source, SaaS, serverless, no code, low code, hyper automation. So these are the following technology which will be having a good amount of overlap with fintech. And fintech now there could be a question like how is it then different from the software patents? I would say definitely they are different from the software patent, but there is a good overlap between a fintech and software patents, because terminologies when it comes to like sending money to ATM or having some transaction without card and all such kind of stuff, those things, those aspects are purely associated with fintech, whereas using of software like or the backend technology of artificial intelligence, blockchain or SaaS or core like hyper automation kind of thing, those will be a software specific thing. So definitely software patents are different from fintech patent, but there is a good overlap between them. So on the same note, right now I will be just sharing a few notable patents which are there in the market, like, and they are associated with big organizations. So the first patent that I want to mention about is Amazon's palm print payment technology, which is a granted patent. Like using the palm, you can make a payment. Like you do not have to even carry card or something or anything. Like you just scan your palm and the payment will be made. Then Square real time transfer. It is, if I remember correctly, this patent was regarding exchange of two types of currencies like Bitcoin versus dollars or something like that. Then there is a Walmart crypto coin. So this patent, which is US 564 Walmart crypto coin, this is under the examination. Okay, above 2 patents got granted, but definitely they went through a good prosecution, trial. This patent did not go through well. So what is their current status is abandoned, because it failed to respond the office action, and now there is another attorney possibly will be taking over this case. So what we can infer is like it's pretty much simple that there is a mixed feeling. Like there will be some patent which you will pass through the bar of examination and get through and get granted. Similarly, there will be patents, no matter how big organization it is associated with, will have the challenges of Alice or say uh, 101, whatever 102, 103. So 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 one has to keep in mind that uh, getting a patent or grant on a patent would not only depend on the merit of the case. It will also depend on how well the application is written and how it is being prosecuted. Similarly, if you see there is a JP Morgan's patent which is granted. This PayPal's patent, this is also granted. The American Bank of America's blockchain-based wallet patent, this is under it is yet to examine. And last but not the least, there was a patent from Snapdeal, which was regarding a alternative to OTP for authentication. If I remember, if I remember correctly, this patent got abandoned because again it failed to respond the office action timely. So from this we can infer that it it is the merit of the case and the way it has been prosecuted which will be taken into account in order to get a grant. So we can say we can, it will be not wrong that to say that okay, you can get a grant on patent related to fintech, but it's not that a easy way to uh, to get that. So, and from the perspective of patent enthusiasts, like people who are already having a background in IP, and they have some interest in fintech, I think just by reading or by going through these many patents, the image file wrapper of these patents would give them a fair idea how at least US perspective is about in terms of patent in fintech. So with this, I will come to the end of today's session. This is the last slide of my session where I have tried to just list down the very basic approach or strategy one should have when it comes to dealing with fintech patent. So the first thing they can do is to, for anybody, like for any startup, and it is, of course it holds good for any reputed company which is well established, they have to identify the novel and inventive aspect of the idea, and for that definitely a patentability search would be a good option, so that you get to know, like, compared to your idea, what all things are there existing in the market, or where you can get some space in terms of drafting the claims or something like that. So patentability search can be a good way to identify novel and inventive aspects. Then caution has to be taken while drafting the patent application. We know that we have discussed at length about how the patent ineligible subject matter can ruin the entire effort of filing and prosecuting application. So one should be very aware when it comes to drafting a patent application. The application should be drafted in a manner that there are fallback options, and where they can use during the prosecution stage for mitigating such kind of rejection. And for that, consulting with an IP attorney would be definitely advisable. No harm, people can write their applications at their own, but many people do also, but it becomes very difficult for a poorly drafted application to be prosecuted with. So this is a request to all the people who are from non-IP and want to do some protect IP in their particular or specific domain, that they should at least take help of the IP attorneys at the time of drafting the application and for prosecuting. So the third point I mentioned is, like, we know that it's not always the case that you are done with all your studies with respect to any idea. There might be a situation where you need to come up with more you have to do more R&D in order to finalize the idea. So the idea is to not delay till the time you perfect your idea. is you can just secure the priority date by just filing the provisional application, and then which can be followed by a complete specification. And finally, based on the business need or the financial position, the patent can be taken to the multiple jurisdiction. So to summarize this particular page, I would say that do a patentability search and get the application written from a IP expert or an IP attorney. These are the most basic approach one should have when it comes to patenting in fintech. For the reason being that we have already discussed, is there are challenges, and the challenges of not being patent eligible matter is the most critical one. So once we take into account that issue and we prosecute well, then there is a good chance that we'll get grant on patent in fintech. So with this, I come to the end of today's session, and finally, I would like to thank everybody for their time. And if they have any question, I think please write it to me, and I will try to resolve, answer them to the best of my ability. And with this, I come to the end of today's session. Thank you, everybody. Have a good day. Bye-bye.